reasons why we ask this question. So I think we should just pay attention to that. So sometimes it's not about asking them for the purpose of testing their knowledge. Also, it's also serve to see or to make them learn something. So, for instance, you may ask a principle that they are not aware of. They'll definitely go and research and go and learn about the principle. Go and learn, we're in session. Go and learn about the principle, and then we take it from there. So I don't know if the judges have one or two questions so that we can admit the students.
Yes, Doctor,
Adebari, any question from you?
Yeah. This is
yeah.
To allow them you brought into their time, and it may seem unfair to them. So let them finish their presentation. When they finish their presentation, then we ask questions. Because each time we keep interjecting, I give them their time. If it is 10 minutes, let their time be 10. Minutes, then we have about 5 minutes for questions, then they have time.
Thank you very much. I'll come to that question. We should remember that if you look at it, knowledge of the fact, correct articulate analysis of the issues, international environmental law, familiarity with authority, drafting style, footnote, and the likes. So, but what I want to say is that we should pay attention. I mean, these are memorial scoring sheets. Just a moment. Let me see the scoring sheet for the. If you look, okay, yes, these are the preliminary scoring sheets. Knowledge of the facts, correct articulate analysis of issues, familiarity with organization, clarity, substance of argument, ingenuity. Now, Dr. Yaleto, I quite appreciate your concern, but you see, the beauty of mooting is, number one, to engage students while there. That's what is different from the proper court. That's why it's called a moot court. So as students are talking, you are expected to interject. It's part of the whole organization of the moot competition. You try to interject, and then time management is also important. So we don't expect them to spend, I mean, each team has 30 minutes, and then our question is part of it, and that's the standard everywhere in the world. You interject, you interject, you interject. Why it should not be more, or it should not be so many, but at least interjection is part of the process. You want to test them. Hope you have not crammed this thing. Hope you are the one that wrote this memorial. Hope you understand the law. So it's part of it. So it's part of the whole stuff. And then when we feel that, and that's why I said asking team questions should not be one-sided. So if, for instance, both teams have been asked questions while they are speaking, nobody will feel unfairly treated. And then we as judges, we use our discretion to give maybe 1 or 2 minutes where we see that, okay, for them to wrap up. But it's part of it's part of the whole process. That's how mooting competitions are done.
Hello,
so
hello, Dr. Lutola. We have students here. We have participants here listening to what you are saying. Would you want them to be excused for a while and speak to the judges? So then they can now come in.
And we can just tell Team 21 to leave and come back.
And let them leave and come back, please.
So I would ask the team 11 and team 21 to kindly excuse us for, say, 5 minutes, and let's put everything together, then you join. Thank you.
Are they out of the room now?
We are waiting for team 21.
They are out.
They are out. They are out.
And you would have told me, like I told you, the admin, we are the one that will tell you to admit them in. They ought not to be admitted at the beginning.
This is the
What?
first day, sir. So we believe that from
No
tomorrow
problem.
we'll
No
be fine.
problem. It's fine.
And
Next
but we
time,
should have also done this briefing, sir, before now, because I told them they will be allowed to come in by 10, and that's what they worked with, sir.
It does not matter. What I'm saying is that yes, I agree with you, but it does not matter. Even though you have already told them that by 10, it's whenever you want to admit them, you admit them. They can be on the waiting room for when as far as you want to admit them. That's why it doesn't matter. But so let us leave it at that. So Dr. Oyaleto, I hope my explanation makes a lot of sense now.
Yes, thank you. But I will want to say that judges too, as judges, we should be mindful that yes, they need time. So for the purpose of which you think there should be interjection, fine, it is valid. Much as we want to test the veracity of their ability to, or whether or not, to determine whether or not they prepared the memorial and it is their work. We as judges should be mindful of not engaging them so long because
yes,
we need to
yes,
assist them
of
to
course,
manage time.
of course. I agree with you. Thank you. That's why I said we try to, for instance, it's not mandatory that all the judges ask a particular team questions. I mean, maybe two may ask this one and the other two may ask the other one. So that's why the question must not be too much. We have to be equally be mindful of that. I agree. Mr. Adebari, do you have any questions or everything is fine so that we can start the session?
For my end, everything is fine. I wanted to confirm the time that they had, but you
No, they
mentioned
are going to write it as they are admitted. They are going to put on the message box the number of time allotted to each of the team. I mean, each of the team has 30 minutes, but they are going to tell you how it's divided. So that if for instance, team applicant is speaking for maybe 10 minutes, you know that this one is speaking for 5 minutes or 10 minutes. They are going to put it on the message box as you start. So, admin, you can please admit the students so that we can start, please. So we'll be waiting for the students. So they are supposed to put their names, their names and their school, so that for the purpose of scoring, the scoring sheet has what's it called? Oralist 1, Oralist 2. So each judge is to have two scoring sheets, and then at the end of today, we send the scoring sheet to the admin so that they can compile it for purpose of determining their scores and all that. So are the teams here? Team 11, team 21. Team 11, team 21.
They will soon join.
No, they have to put their name and their team number. We have to write the name on the score sheet. Their name and their team number. Their name and their team number. Of course, they enter the room with their name, with their team number. Then they tell us they write their names there. Their names, not their school. If, for instance, Bola is representing school as applicant team 1, if Kola is representing, they put it there so that we know who we are scoring. Their names are necessary for our score sheets.
Okay, so team 21 is here. We're waiting for team 11. I'm trying.
Yes, team 21. Good morning. Good morning. How are you guys? Team 21, can you hear us? I guess they cannot hear us. Team 21. Hello, team 21.
Hello, Dr. Olusola.
Okay.
Hello, Doctor.
Yes.
Dr. Olusola.
Yeah.
Please,
Yeah.
these two teams, please let us know which is applicant and which is respondent.
Yes, team 11 is applicant, team 21 is respondent. Team 11 is applicant, team 21 is respondent.
Thank you.
Team 11, team 21, are you guys here? While if people can hear me, kindly write your
They are
name.
not yet here, sir. So I'm sure they will join us shortly. So I've sent a message that they should join us. Just a moment.
You can't see it, man. I don't know. Unioshun is not online. Look unmuted. Look unmuted.
We are waiting. It's taking a bit of a long. What's the problem?
So
We
we're
are
calling
waiting.
them. We're calling, maybe they have technical issues. I don't know, but we're calling them.
Okay, I think Team 11 is here.
Okay.
Team 11, you are welcome. Please.
Thank you very much.
Yes, please kindly put the name of the team members and your allotment of time, how you intend to argue, so that we know for the purpose of recording our score sheets, so that we can start.
Should we put that in the chat box, or should we
Yes,
just
the chat box. Please put it in the chat box.
it?
Your name, I mean the name,
All right.
and then the amount of time each of the speaker is speaking. Your name.
All right.
Yes.
Noted. Thank you very much. Noted.
Please, can we have your video on, please, Team 11?
All right. I need a confirmation that you can see us.
Yes, I can see you guys. I can see you. I can see you, Team 11. Yes.
Team
Please
21 is
write
also
your
here. Team 21 is also
Team
here.
21, you are welcome. You are welcome. Please, kindly, would like to see that we are not listening to robots. So we appreciate if your videos are on. And then please put your names and your allotment of time in the chat box so that the judges can have them and record. Thank you very much. So that we can start in a moment. You're already running out of time. Thank you. Team 11, the names of the first and second speaker, and then your allotment of time. Team 21, the name of the first and second speaker, and the allotment of time, so that we can record, we can put your name on our score sheet. Just your name, your first and last name, and who is speaking for what time. Make that snappy so that we can proceed to the business of the day. Thank you.
Team 21, can we see both oralists or both speakers? Please confirm that the both oralists are in the same space, please. Team 21.
So Team 21, we are here to see you. We are waiting to see our respective counsel. Make it snappy because we are running out of time. We are still waiting. We are yet to see the names. Team 11, Team 21. Kindly put it on the chat box. We are waiting. Put your names on the chat box so that we can put it on our score sheet. And we'll start. Just type in there. Type it there. We are waiting. It's taking almost forever. Thank you. So, judges, the names are there. So let us try to put it on our score sheet.
Good morning. Please, my team are trying to join. They are told the host has not accepted them on. Please, can you?
Okay,
can
the host will definitely accept. Hope they are joining as Team 21.
Pardon me, sir?
Hope they are joining as Team 21 because the host may not be able to admit any faceless person except they are joining as Team 21.
Okay, they should label it as
Yes,
Team
of course.
21.
That's the only way they can know who is trying to join.
I'll inform them now because we are not at the same place.
Yes,
Okay,
but while we are waiting, if you have their details, you can put it for us so that when they come, they just start. If you have their details, you can type into the chat box. So don't waste additional time.
They are already
all right. 1 minute, sir.
One is already in. Can see them.
So who's next?
The admin said one of the Team 21 is already in. Kindly put the name of your name and then the name of your partner on the chat box so that we can have this. It's almost 30 minutes past time of the court session. Team 21, you're waiting. And I think the teams should note that it's quite not our culture to waste time like this. So I want to admonish you guys that your next session, please ensure you come and as expected.
Yes,
so,
sir.
Georgia
Sir, I would
Debari,
also ask the coach to tell them to check their internet because we have opened it now and they can have access to it. So I'm surprised that they are saying that they've not been allowed into the meeting. Please tell them to check their internet, their network.
coach for Team 21, can you please tell your team members to check the network signal wherever they are to be sure that all is well with their network. Now, Georgia Debari, I believe you can see.
I have done that.
So Sarah Atere will be speaking for 15 minutes, while Abdul Qadri Ajenia will be speaking for 10 minutes, and then they have reserved 5 minutes for reporters. Yeah. So that's how they have chosen to share their time. So, team coach, we are waiting. We are waiting. We are waiting. So team 11, you are welcome. We have 3 judges sitting. I am Dr. Olutola. We have Dr. Oyalito, and we have Dr. Adebari. 3 of us will be sitting for this session. So please enjoy your time before us. I believe we are equally going to enjoy our time before listening to you guys' argument and putting forth. Admin, was the
Yes,
Team
sir.
21 in before now?
No,
their coach.
It's their coach that has been in.
That
I thought they were in the same place. I thought they were in the same place. So that was why I was asking to see their faces. I didn't know it was just the coach. The coach has been in the meeting ever since.
I think they should
Oh, I
check their
see.
network.
Yes, I think. Or is it possible for us to start with team 11 and they will now come in?
It's always good for the 2 teams to listen to each other.
Exactly.
Let's just wait here about 10:30 and let's see. Coach 21, Team 21. Any information from your team members?
I'm very sorry for this. I think it's my mistake. I was supposed to send them the link earlier. I thought they would have the information as well. So I joined expecting them to be here. But they are trying to do that right now. I don't know. By now they should be here. I don't know what is happening over there.
Okay,
I
but
just
you
finished
guys are
speaking
not
with them.
in the same place, right?
No. Right now I'm not in school.
Okay, no problem. It's fine. It's fine. Let's just wait for them. Tell them that they are the one we are waiting for. That's good.
Doctor,
Yeah.
there is a problem. You just said there is no problem. This thing was said. Someone who is a coach just said that he did not send the link. He thought they would have the link. We're supposed to have started because ought to have commenced, the session ought to have commenced by 10 a.m. Let's check the time. He's their coach, for God's sake. He got a link. And for our players, so to say, let me say players, he did not send them the link. And we are here. Eh? It's unfair.
And Dr. Oyalito, please, I understand your challenge, but please, let's just try to empathize with them. Let's just wait till 30, and if not, maybe we have to start with the team 11 if they are not entering anytime soon, because we have to proceed. Because I understand you are a very busy person, and I'm very sure you work with time and all that. So we are extremely very sorry, and we deeply appreciate your time.
I think they are here, sir. They are
here now.
Good team 21. Can you please give us your names? Make that fast. Put your name on the chat box so that we start this session.
Type your name as a message on the chat box, please.
On the chat box, and tell us how much time each of the team member is spending. Is it 15 or 18, 12 or whatever? Let us have it on the chat box, please. We are running late, please.
Team 21, what you do is you put your team 21, Oralist 1. You put your name, team 21, your name. Let's say Peter Jacob, 15 minutes or 20 minutes. Then the next Oralist, Joy.
No, we don't want that. This arrow you are doing, we don't want to. Arrow. Okay, team 21. Your name, yes.
Put it together as a message, please, so that we can understand what you are saying.
Yes, you can put the first team.
Just take your time. Put your team 21, your name, the minute you'll be taking, then the next name and the minutes that person will be using, please.
So we are waiting. Please make that to be very fast. Okay, good. I believe Raymond is your first name, team 21. Raymond, or is it Osuda as your last name? Just put
Raymond Ibelsu.
Raymond is the first name, right?
Yes, sir.
Thank
Yes.
you. So, team 21, you are welcome. So we are going to start straight away. We have seen your time schedule, and I believe George Adibari have seen it, so that we are starting this session right away. Team 11, I believe you are ready. Over to you.
Before we respect this Palo Temple of Justice, announcing appearance before your excellencies is S.E. Atere, lead counsel for the applicant. And appearing with me is A.O. Ajenia, co-counsel for the applicant. Together, we announce appearance as counsels for the applicant.
Proceed.
All right. Period of 30 minutes have been allotted to canvass our argument before this Honorable Court of Justice. As I'll be canvassing the preliminary issues as well as merit A and D for the period of 15 minutes. 5 minutes for our rebuttals. My lord, on the issue of jurisdiction, the applicant firmly averse, Your Excellencies, the applicant firmly averse that this honorable court is furnished with the requisite jurisdiction to entertain and decide this instant case. Article 3, sub 1
Counsel, announce your appearance, your names. You need to put your names down.
Okay, I already did that, sir. You told me to proceed. All right, sir.
Your name,
Once
each of you, not appearing with you is.
We already said that, sir. We said appearing
okay,
with before your honor.
Okay, maybe the network.
Right.
Sorry.
Okay.
No.
Okay, let's just start again, sir.
Proceed.
For
No, proceed.
clarity.
Proceed.
No, just proceed since you have done that.
Okay. My lord, the applicants firmly averse before this honorable court of justice that this court has the requisite jurisdiction to decide and entertain this instant case. Article 3 sub 1 of the Protocol to African Charter on Human and People's Rights states that this court has the jurisdiction to hear and determine matter concerning the interpretation and application of relevant human rights instruments ratified by the concerned. My lord, the court affirmed its position in the case of Democratic Republic of Congo and Republic of Rwanda, where it held that Article 3 sub 1 of the protocol gives its jurisdiction whenever an applicant alleges the violation of human rights protected by the Charter or by any other human rights instrument which the state is a party to. My lord, furthermore, in the case of Tembo Hussein and United Republic of Tanzania, the court proactively affirmed its decision insofar as the court alleges that a violation of human rights has occurred. My lord, the court states that particular court shall have the jurisdiction. And Lord, given that the subject matter of this suit falls strictly within the domain of human rights violations, my lord, the applicant so humbly submit that this court possesses the right jurisdiction for that matter. My lord, on the issue of admissibility, admissibility of applications by this court.
Counsel.
Yes,
before
my
you
lord,
proceed
your
on the issue of admissibility, do you want to entertain this, educate this court on the types of jurisdiction that this court possesses? Does this court have different types of jurisdiction or not?
My lord, just like the word jurisdiction, it means that the court has the power to entertain a matter. So we are saying that on this instant case, which its domain is on human rights violations, we're saying that this court possesses the requisite jurisdiction, which is that they have the right to hear and entertain this matter, my lord.
Well, thank you. But I don't know if you by any means have heard about the temporal jurisdiction, the territorial jurisdiction, and material jurisdiction of this court. Are you aware of them?
Very well, my lord.
So can you educate us? I discussed this court about the temporal jurisdiction, the territorial jurisdiction, and the material jurisdiction of this court.
My lord, material jurisdiction is that the subject matter is within the domain of human rights violation, which we say that yes, it is indeed within the domain. Territorial jurisdiction is whether a party, whether or not the court is an entity, but like if both parties are a party to that particular protocol or to any other relevant instrument, then that court, even if it's not a party to such protocol, can entertain such matter, my lord.
What about the third one?
Which is the temporary jurisdiction, my lord?
Yes, please.
It means that in certain situations, if the subject matter is not just on human rights, if it is on other parts of maybe it relates to other parts of like law or anything, the court can have like temporary jurisdiction just because the subject matter is still revolving around the domain of human rights violations, to the best of my knowledge, Your Excellency.
You may proceed. Proceed.
Very well, Your Excellency. My lord, on the issue of admissibility, admissibility of applications by this court is provided for in Article 10D, subparagraph I and II of the supplementary protocol. Provides 3 criteria for an application to be admissible. 1, the status of the applicant as a victim of human rights violations must be established. 2, the application shall not be anonymous. And 3, the application shall not be instituted before another international court of adjudication. However, it is crucial to bring to the notice of this court, the court has already expanded its scope of admissibility and has shifted from the strict interpretation of the first criterion, which is that the applicant must be a victim. And the court, in its wisdom and progressiveness, had this to say in Registered Trustees of Faculty of Peace and Federal Republic of Nigeria, where it states that any violation of human rights, which is brought, my lord, in a representative capacity on behalf of individual victims shall be entertained, my lord. My lord, while maintaining that legal entities such as NGOs can institute actions in a representative capacity, but in the Registered Trustees for Socio-Economic Rights and Accountability Project, hereinafter called SERAP, the Federal Republic of Nigeria spelled it out that even those jurisdictions, we started embracing a strict legal interpretation of the victim for the purpose of human rights protection, evolved into a more flexible approach in order to allow other persons to bring their case for the victim to hold them accountable for the perpetrator. Now, the facts in paragraph 16, lines 4 and 5 reveal that the applicant is a non-governmental organization duly incorporated in the state of either, thereby making it a legal person. The fact also in paragraph 16, lines 5 to 7 reveals that the applicant declared in August that he was in talks with the victim to represent a case at the African court, which clearly signals authorization from the victims to represent them. But marrying this benevolent pronouncement of the court with this fact, it is logical to conclude that on the first requirement, the applicant has instituted the action in a representative capacity. And the second and third requirement, the applicant proceeds before this honorable court that they are fully satisfied. Your Excellencies, hence, in accordance with the jurisdiction of this court, the applicant submit that this instant matter be admissible before this honorable court. My lord, moving on to the substantive argument before this honorable court of justice.
Counsel, before you proceed,
Your Excellencies,
you have raised the case of SERAC and Nigeria.
Very well, Your Excellency.
Do you want to tell us the status of that case before this court? And then,
my lord, okay,
just a moment. Tell us the status of that case before this court. And secondly, can you please address this court on the issue of exhaustion of local remedy, which remains a cardinal principle as far as admissibility is concerned?
Very well, Your Lordship. My lord, just like every other case, there can be other words mentioned by the honorable court, right? But as regards to admissibility, in that case, the court held that expanded its scope to the admissibility, not just to victims, that is, even people that are non-governmental organizations, as long as they are incorporated, my lord, into the laws of that particular land, they can sue as a representative capacity on behalf of the victims, my lord. Those were the words of that was held in that particular case. My lord, as regards extortion of local remedies, my lord, it is right.
Counsel, you didn't get my question. Permit me to rephrase my question.
Okay,
My question is that CERAC and Nigeria is a decision of the African Commission on Human and People's Rights. My question to you is that of what value or what is the status of that decision before this court? That's my question before the other question about jurisdiction.
My lord, is it about as to whether it's binding or persuasive?
Yes, please.
Okay, my lord, it is binding because international law basically has to do with whether or not a law cannot necessarily be like, okay, you have to follow this law. However, it serves as a guide for other or subsequent cases, my lord. Since it was held in that court, it could be said that it could be binding, my lord, on this particular instant case, since it was similar, and we are also talking about the same instant matter.
Thank you. So address court on, because I realized from the fact of the case that some of the issues that are brought before this court have not been entertained or have not local remedy has not been exhausted concerning them. Can you please educate this court on the position on international human rights standards as far as local remedies are concerned?
Okay. Very well, my lord. But it is notable that remedies are to be exhausted like locally. However, my lord, when that particular violation or that infringement has to do with a particular protocol that binds internationally, my lord, just like in this case, the declaration of Article 34 sub 6 of the African chart of the protocol as wants to be withdrawn by the respondents, my lord. Hence, we are using this medium to come to the African court to relay our matters. And why it is notable that yes, we could exhaust local remedies, it still does not restrict or it does not prohibit us from still coming to the African court to relay this matter, my lord. And as long as it still even has to do with a protocol which a country wants to forcefully withdraw from without legal basis, we have every right to be here before this African court to relay our matter, my lord. Your Excellency.
Thank you. You may proceed.
Very well, Your Excellency. My lord, on the first merit, which is the withdrawal by IDERA of its Article 34 of 6 declaration, it violates the African Charter and other relevant human rights instruments by undermining the vested rights of the indemnant. Your Excellency, the applicant contends that the purported withdrawal of the Article 34 sub 6 declaration by the Republic of Edera, hereinafter called the ROE, is invalid. It violates the African Charter on Human and People's Rights and other relevant international human rights. My lord, the said withdrawal constitutes an attempt to deny the citizens of Edera their vested right to justice before the African court. Paragraph 2 of this fact reveals that OE had ratified African Charter on Human Rights and People's Rights, the protocol establishing the African Court, and other international human rights instruments. However, it's a well-set principle of customary international law that states which have ratified a treaty bound to perform their obligations in good faith, in accordance with the maxim acta sunt servanda, which means agreements, my lord, must be kept. This principle is codified in Article 26 of the Vienna Convention on the Law of Treaties, which provides that every treaty in force is binding upon the parties to it and must be performed by them in good faith. My lord, the relevant provision of Article 34 sub 6 of the protocol reads thus. As said by Senator to read verbatim. At the time of the ratification of this protocol, or any time thereafter, the state shall make a declaration accepting the competence of the court to receive cases under Article 5 sub 3. The court shall not receive any petition under Article 5 sub 3 involving a state party which has not made a declaration. My lord, this provision creates an optional jurisdictional clause by which the state allow individuals and NGOs to bring cases directly before the African court. My lord, it is sacrosanct to bring to the notice of this honorable court that the withdrawal by the respondent has no legal basis, and it has even failed to comply with the formal and procedural requirements established under the protocol and international law. My lord, a withdrawal that does not follow the due process of law is null, void, and definitely of no effect. Article 34 of that same protocol provides the formality for declaration to be valid. It states that the declaration made under paragraph 6 above shall be deposited to the chairperson of the committee, who shall transmit copies thereof to the state. This means that both the making and the withdrawal of such declaration must follow formal diplomatic processes. That is, they must be in writing, signed by a competent authority, and formally deposited to the chairperson of the African Union Commission. But in the case of actions post la protection de droit de l'homme and Côte d'Ivoire, full citation before your lordship, it states that declaration made by Article 34 sub 6 is a sovereign act of the state which must follow formal procedures required for the international instruments, confirming that it must be made and withdrawn formally. and not merely announced. But the above reasoning was reinforced in the case of Inagbire Victor Umoza and Republic of Rwanda, where the court held that a withdrawal of a declaration must be formal, written, and also made by a competent authority, as well as deposited, my lord, with the AU Commission. It takes only effect for future cases. And in this instant case, the Republic of Edera failed to comply with these procedural requirements. The purported withdrawal was not communicated to the AU Commission nor properly deposited by a competent authority, thereby making it ineffective in law. But this honorable court shall hold that even if a valid withdrawal adult court, such withdrawal cannot
Say you have 2 more minutes left. You have 2 more minutes left.
Very well, Ma. But the question is that okay. Okay. It was because of the questions and answering.
Not at all. It was please, for the purpose of notifying them the time, can you put it on the chat box so that the admin judge can see and notify them so that they don't interject them. Just put it on the chat box so that we can follow.
Right.
Proceed.
All right, sir. Just to reiterate that it was the questions that took our time as well. Also, moving on, sir, that those effects cannot have retrospective effect or even extinguish the rights vested in the individuals. But the Republic of Edera, having made declaration about this situation, states that they have the right to actually proceed into this particular matter, and then the right of the actions of their respondent is only expected to restrict them from actually working. But in light of the foregoing, the purported withdrawal by the Republic of Edinburgh is invalid, unlawful, and of no legal effect, as it failed to meet procedural formalities. And on the second merit that Edinburgh violated the African Charter and other relevant human rights instruments, they're failing to ensure that Bashi people and the child workers are protected by violations committed by the QHL. As a prelude, it is pertinent to remind this honorable court of its long-standing decision as it relates to state responsibility under international law. Still note that a state party to international human rights is responsible for the violation of the rights of its citizens by conduct of any organs empowered to exercise elements by the government authority. According to this fact, it is submitted that the act of QHL having constituted multiple violations of human rights attributable to the government, thereby rendering them liable. Now, to properly elucidate this issue, we will say that it is the primary duty of the state to protect its citizens. The use of force and forced evictions violates right to life, dignity, property, and health under the African Charter. The exploitation of child workers, both the African Charter and other relevant human rights instruments. My lord, it is the primary duty of the state.
Counsel.
Very well. Yes, my lord.
Your time is up, but nevertheless, we'll give you 2 more minutes to try to wrap up.
Thank you very much, Your Excellency. And on the first substantive issue, on the first standpoint, we are basically saying that the applicant or the respondent failed to discharge its obligation to respect and promote and fulfill the rights guaranteed under African Charter and people's rights. The case of Serap and Nigeria is instructive. Therefore, Edera failures to regulate and monitor the activities of QHL led to violation of its obligation under the Charter. On the second standpoint, we are saying that Article 4, Article 5, Article 12, Article 14, 16, and 18 of the African Charter has already protected these people's rights. The actions of the respondent clearly, my lord, infringes on this individual's rights with the excessive use of force, degrading treatment, or others, as held in Zimbabwe Human Rights and Zimbabwe, as well as Egyptian Initiative for Personal Rights and Egypt. My lord, on the third standpoint, that Article 15 made it clear that it guarantees the right to work under equitable and satisfactory conditions. And Article 18 requires states to protect the right of a child stipulated in international declaration. By allowing QHL to employ and expose the children to hazardous conditions, Edera has failed to protect its children. The case of Serap and Nigeria is still instructive as to this issue.
Thank you.
Answer by Synod Court to resolve issue merits A and B.
Thank you. Thank you very much. Thank you. Let us hear from the second counsel. Yeah.
All right, so before I proceed, I would like to confirm, when a question is being asked, will our time be paused or will the time continue?
Not
because
at
according
all.
to the criteria and guidelines of the competition, every question
is part of the competition. So your time counts as the question is on. The question is part of the competition.
Just to pinpoint, sir, the competition guidelines stated otherwise. So I would like if you could be taking note of, sir. Because competition says that the guidelines stated that when a question is being asked, there will be a pause and we prepared in that manner. But I will do as the Lord, as Your Excellency pleases.
Proceed.
Thank you very much, Your Excellency. I'll be starting my presentation in. Thank you very much, Your Excellency. I'll be starting my presentation in 3, 2, 1. As earlier announced, my name is A.O. Ajenia, counsel for the applicants, and counsel shall be addressing this tribunal on the merit C and merit D, respectively. On merit C and merit D, respectively. On merit C, which borders on whether or not Public Order Act of the Republic of Edera violates international human rights law. The applicant contends that the Public Order Act constitutes an unjustifiable restriction on the right to peaceful assembly, where Section 13 provides that organizers of protests are required to obtain permission from the Office of the Inspector General 14 days prior to the protest. The applicant argues that this section violates several international human rights instruments already ratified by the respondents, the Republic of Edera. The right to freedom of assembly has been recognized by numerous human rights instruments, of which the respondent has fully ratified and is legally bound by. They include Article 11 of the African Charter of the Human and People's Rights, Article 21 of the International Convention on Civil and Political Rights, Article 8 of the African Charter of Rights and Welfare of the Child, and Article 20 of the Universal Declaration of Human Rights. Article 1 of the African Charter imposes both positive and negative obligations on state parties. The positive obligation is to protect human rights, and the negative obligation is to refrain from acts which interferes with the rights of individuals under the Charter. Your Excellencies, while the right to peaceful assembly is not absolute, any restriction must comply with the tripartite test of legality, legitimacy, and necessity in a democratic society. The impugned provision not only imposes an impermissible prior authorization regime, but also fails to meet the requirement of proportionality, thus breaching both the state's negative duty to refrain from interference and its positive duty to facilitate the enjoyment of these rights. In the case of Williams and Zimbabwe decision, the African Commission on Human and People's Rights established its imperative for states to not impose undue restrictions on the exercise of the right to assembly, and states must ensure that the freedom is enjoyed in a practical manner, Your Excellencies, practical manner. Furthermore, paragraph 66 of the Guidelines on Freedom of Association and Assembly in Africa, which is observed to have been applied as a navigator in several cases touching on right of assembly, it stipulates that when states enact laws on freedom of assembly, those laws shall aim primarily at the facilitation of the enjoyment of the right. Paragraph 71 additionally provides that participating in and organizing assemblies is a right and not a privilege. And as such, its exercise does not require the authorization of the state. Also, when there is a failure of notice, the assembly is not to be automatically penalized or dispersed or sanctioned. Paragraph 72 stipulates that such notification requirements are to be non-burdensome, and the notice period is to be as short as possible. It is indisputable that the provision of the Public Order Act imposes a limitation on the exercise of rights to assembly, a requirement that not only must the Inspector General of Police be notified 15 days prior to the protest, but also he must authorize such protest. This cannot be said to be legitimate, necessary, or even proportional to the intended objective or even accepted limitation to the exercise of the right. And as affirmed by the Honorable Court in the case of Loe Issa Konate and Burkina Faso, and the case of Sebastian Jamin Marie Aouko and Republic of Benin, when such requirements are not met, the right of assembly is considered to be violated. The notification requirement fails to facilitate the exercise of these rights, and it's ought as it was supposed to be, and it merely impairs the essence of the right, aimed at discouraging participation in assemblies, then the government does not even consider suitable. Or, my lord, see, it is very clear in this situation that all of the restriction and the injuries placed by the authority, Inspector General of Police, was stated there to prevent the government from facing accountability. And this is not supposed to be in a functioning democratic society that has ratified the principles of the African Charter of the Human Rights, the Universal Declaration of Human Rights, and other international conventions. In light of the foregoing arguments, the applicant submit that Section 13 of the Public Order Act is inconsistent with the respondent's international obligation, conditioning the exercise of the rights to peaceful assembly on prior authorization from the Inspector General of Police and imposing an unreasonably long 14-day notice period. The respondent has enacted measures that is not lawful, necessary, or proportionate, and we pray that the court rules in our favor. Your Excellency, on the
Counsel, now I've listened to your argument about the prior authorization.
Yes,
now,
Excellency.
can you address this court? If you look at the facts, relevant paragraph of the fact, in the states, most of the assembly that were held turned violence. Now, how do you counterbalance the enjoyment of human rights and the state's obligation to protect properties and life. How do you expect the states to have counterbalanced it rather than giving a pre-authorization? That's one leg of my question. The second leg of my question is that, can you show to this court relevant authorities that prohibits prior authorization under human rights law?
Your Excellency, it's important to have that in mind because that statement of fact, which shows that the protest was peaceful until the state decided to
What
releasing.
What paragraph of the fact says so? What paragraph of the fact says so?
Paragraph 27. The General Anthony sent out 3 armed special forces units when the police were unable to quell the protest. The protest was as peaceful as possible until the state sent it. The first time the protest happened, the state released tear gas, and people gave instances where particularly Doris, in a blue, where she cited a blue bus.
If you look at paragraph 27, it says that blocking traffic and disrupting activity. What's peaceful about that? What's peaceful about blocking traffic and disrupting activities?
Your Excellency.
Paragraph 27. Paragraph 27, in fact.
Your Excellency, blocking traffic and disrupting activity, it is not valid enough reason to send in 3 different buses of officials that are not even recognized by the state to start firing shots. Is blocking traffic proportionate for a person's death?
Counsel, just wait. I'm not justifying the action of the state. I'm just taking you up on the paragraph you raised. You said the protests are peaceful. But I'm looking at paragraph 27, shows that a protest where traffic are blocked, where activities are disrupted, does not speak of any peaceful protest. But my question to you is that, how do you expect state? I mean, looking at the fact that state has the primary responsibility obligation to protect life and property, how do you expect? And if you look at the facts of the case, you see that governmental property were destroyed and all that. People even lost their life as a result of the fracas. What do you think? Because you have to understand that you have argued here that peaceful assembly is not an absolute right. So I'm asking you a question. How, so that this court can be properly guided, how do you think the state is expected to counterbalance the right to peaceful assembly and the obligation to protect life and property? That's one leg of the question. Number 2 leg of the question, which I want to address, is that, are there international authorities, I mean, laws under international human rights law that prohibits prior authorization? If they are not, what are the thresholds when it comes to prior authorization under international human rights law? I want to address me on these 2 issues before you proceed.
Okay, thank you very much. Your Excellencies, on the first question, I would like to answer that the protest was as peaceful as possible until there was an unlawful state interference. In an ordinary and a functioning society, the state should have not interfered in that manner. Instead, the state should have provided them security. Your Excellency, I'm trying to answer the question.
Wait, Counsel, listen to the question.
In answering, you still have the duty to answer directly. And in a simple term, what you are being asked to do is to tell us what amounts to a peaceful protest. What are the indices, the elements of a peaceful protest? Just simply tell us where a protest where people who are supposed to go to hospitals, who have appointments in hospitals, are not able to go. People cannot go to their various businesses because of the blockade of certain people who believe that they are exercising their rights. So what does the state do at that point where protesters, so-called protesters, block the road and thereby violating my own right of freedom of movement? So what is peaceful about that? Is there anything peaceful about it? That is the
Your Excellency.
So you let us know if it is peaceful.
Okay, thank you very much. Your Excellency, in that situation, the state is supposed to release security officers who were supposed to regulate the conduct of the protesters. If the state has offered security officers from the start, they would have coordinated the activities of the protesters, coordinated the traffic, and everywhere. Freedom of expression from those persons were not necessarily disrupting the freedom of expressions of others. Just that the state has failed to implement proper measures to regulate the activities. And in this situation, we're arguing that releasing tear gas and sending out firing squads to kill civilians was not the appropriate thing to do by the state. There were better things that the state could do. Lives were at stake. People were dying. People almost ate. An Okada driver lost his source of income. He was fired on the head. Persons were fired on their chest because of a protest. The state should have sent in security officers to conduct and regulate the activities of the protesters. Tell them where to be, tell them where to pass, tell them where not to pass. But instead, the state was instructing on regulations that should have been done, which was not supposed to be the case. On the second question about participating, while we acknowledge that the state has not done what it was supposed to do, in the case of Williams and Zimbabwe, the African Commission on Human and People's Rights established that it is imperative for states to not impose undue restrictions on the exercise of the right to assembly. Your Excellency,
Councillor, your time is up, but try to wrap up your thoughts just with 2 more minutes.
Okay, I've answered on the first question on the third merit. I've answered two major questions. Now on the fourth merit, and on the fourth merit, on whether or not Edera violated the African Charter and other relevant rights on the right of Mr. Jude and Mr. Marcos. This merit will be divided into 2 standpoints. The one, their rights to liberty and security has been violated, and the right to expression of opinion too has also been violated. Article 6 of the African Charter and Article 9 of the International Convention of Civil and Political Rights guarantees that no one shall be subjected to arbitrary arrest or detention. The actions of the respondent by arbitrarily arresting Mr. Jude and Mr. Marcos constitute a violation of this provision. A case of African Commission on Human and People's Rights and Libya supports this. And also said in paragraph 27 of Statement of Fact, General Anthony sent out 3 armed special forces unit where police were unable to quell the protest. It was not the fault of these persons at all. It was not the fault of Mr. Jude and Mr. Marcos. They only led the protest, and the arrest was unlawful. The conviction too was unlawful. This was also supported by the case of Alex Thomas and United Republic of Tanzania. On the second subdivision, that their right to expression of opinion has also been breached. The conviction and subsequent imprisonment of Mr. Jude and Mr. Marcos for an offense arising from a public protest constitutes an unlawful restriction on Article 9 sub 2 of the African Charter, which affirms that the right to express and disseminate opinions, it guarantees this right, and they've ratified it. So arresting these persons who were just exercising their rights is a contravention with that provision. And also Article 19 of the International Convention of Civil and Political Rights. The true violence of Article 9 sub 2 lies in the chilling effect that the that the government, that the state imposed severe penalty on the Ederian population using a non-discretionary 3-year sentences against protest leaders. It sends a clear message that they don't want every other citizens of Edera to protest. That means they are trying to not just infringe the right of just 2 people, but the right of every citizen of Edera from protesting. If you can give a person 3 years imprisonment without the option of fine, it contradicts everything that we're standing for our fundamental human rights. And this is not supposed to be the case. We pray that the court rules in our favor. We urge this court to provide remedy that restores the integrity and the legality. We urge this court to provide remedy that restores the integrity and the legality of the Republic of Edera. Thank you very much.
Thank you very much. Thank you very much.
Before we end, I would like to adopt the prayers as it is.
No problem. We have your brief. We have your brief of argument, and we have seen your prayer. And so we'll definitely take into cognizance your prayers and all that. Thank you very much.
Thank you very much.
So now we return to the respondents for their own argument. Yes, Team 21, over to you. Hello, Team 21, are you there? Team 21. Only the coach I can see. Are they here, Team 21? Oh, we can't hear you if you are speaking. Team 21. Yes, please try to work on your microphone. And but we can't hear them. I think maybe where you are, the network's a bit bad. That's why we can't hear you guys. So what do we do? Let's wait till about once 11:10 and we cannot.
Team 21, can you use another device to log in, please? Use another device. Use another device. We'll wait for you.
You wasted too much of time. Once it's 11:10 and we don't have anything, we call it a day here. We have other engagements. So once 11:10, they are not speaking. Possibly the organizers will have to reschedule them for them to speak some other time. We have other engagements. So once 11:10, they could be organized to, or possibly when next they have a better network, then yes, but you are wasting our time. We wasted our time for us to commence the session. We are not going to allow you guys to further waste our time. Once it's 11:10, we bring the session to a close, and then the organizers can then give you guys. Everybody on this panel are very, very busy people, extremely very busy. Extremely very busy. But we are doing this to support the grooming of future lawyers and to help you guys. But nevertheless, you must equally have respect for our time. In a commission like this, you ought to have done a test run on your internet. You have to have done a test run on the device you'll be using before today. It's not today that you're going to waste the precious time of the court. We are extremely very busy.
Can you hear?
Yes, you can proceed with your argument. We can't hear you.
We
can barely hear you, sir.
Can you change your network? It's showing here that Team 21's network bandwidth is low. It's your network, please. Can you get a backup or an alternate network, please?
Well, so sorry, Mike. It's because of the location of our school. The network isn't really so good now.
Good morning. Hello?
Team coach, you have not done well. That's the truth.
Yes, good morning, sir.
You have actually not done well at all. We have to be very frank with you.
I'm very sorry about what is happening.
The people you are seeing on this panel are extremely very busy.
I understand, sir.
We made a lot of effort to get them to do this thing. And then you don't want to waste their time.
I apologize sincerely. I'm very sorry.
Can we just have it started now so that we can proceed?
Looking at what is happening now, sir, I don't think they'll be able to present.
Okay, no problem. So what I think is that we call it wait just a moment. We call it a day, then they can be rescheduled for a different session.
No, sir.
So thank you very much.
Your Excellency.
So I think Team 21 can excuse the court while we address the Team 11 and call it a day.
Your Excellency, we wanted to be different bandwidth.
Team 21, please exit the courtroom.
Somebody is trying to talk. I think you should hear the person out, please.
No, the lady said the coach has spoken that they may not be able to proceed.
All right.
So I think
because I can see that the network is vibrating. And
yeah. So I think what I think, Coach, please, what I think is that there's no problem. I think maybe after now, you guys try to get yourself the internet and all that. Then I think the local organized committee can organize a different session where your team can be opportune to speak.
All right, sir.
Thank
I
you.
appreciate that,
So
sir.
you can exit the courtroom. Thank you.
Thank you.
Yeah. So, admin, please let Team 21 exit, and then we hear feedback from the judges, and then we call it a day.
Okay, Team 21, kindly exit this meeting.
Yes, let them.
You will be rescheduled. Don't worry about that. But just exit the meeting so that we can tidy up.
So, admin, please let us know when they've exited the room. They should exit the room, please. Exit the room for rescheduling. You will schedule for another time. Thank you. So I believe they've left.
Yes.
Let's start with Dr. Adebari. Please, your comments, your advice to the team, what you think they've done well, what you think they have not done well. Please kindly give them, because they are still going to face another round, so that they could pick up the lessons they need to learn. Okay, yeah, sorry. We know that they have a reporter. Funny enough now, there's nothing to report. So there's nothing to report. So, well, it's fine. Yes, please.
Hope we're not going to be required to represent our case
No,
when
not
they...
at all. Not at all. You are presented, yes. You have not.
Yeah, but it would be largely unfair if they present their case and you perhaps air them and not our rebuttals. Just to put it out there.
Well, I think that's good. But let me just be very frank with you that I'm very sure the organizers are very fair-minded, who will ensure that their presentation will not in any way prejudice your own presentation. So just be rest assured. We understand that you guys are the one that have done the right thing, they are the one that have done the wrong thing. So no matter, they will definitely take cognizance on that, will not allow them to now use their own stuff to prejudice you guys. So be rest assured, the organizers will put that into consideration. So thank you for noting that and then making us to put that down. Thank you. So I think let's hear from the judges. I mean, at this time, judges are supposed to give you guys feedback, and then so that at least you pick up one lesson or another, so that when you are doing your other presentation, you learn from this and all that. I mean, no hard feelings, just for you guys to prepare better and do better in the next round. So let us hear from the first judge, Judge Adebari, what she has to say to you guys. I mean, her comments so far.
Thank you so much. Thank you. I recognize the other judges in the room. Thank you so much. In the courtroom, thank you.
Unmute yourself. Yeah.
Yes, can you hear me now?
Yeah.
Okay. So I recognize the other judges in the courtroom, and I want to commend the students. That was a very good presentation. Just a few things to highlight. Well, now I could hear while you were putting out your arguments, you were addressing the judges as Your Excellency. Although I don't know where you address judges as Your Excellency. I think you use, if it's a single judge, you use my lord. If you're talking to a number of judges, Your Lordship. So do you understand? I could hear you say Your Excellency.
Please, my lord, please. I think in international courts. Am I on in international court?
Yes.
It is Your Excellency that is used. No, my lord.
Okay.
That's correct. That would the guideline permits them to use Excellency. Yeah, that's true.
Oh, okay. All right. Okay, so if you are permitted to use that, then that's okay. That's fine. Okay. So another thing I want to say is that I could, in your argument, I think Sarah, yes, I think you should be. I think you were talking too fast, and at some point I couldn't even speak what you were saying. You want to make your arguments very clear. You want to make it very clear so that the judge can actually listen to what you are saying and take note of what you are saying. So I think you were speaking too fast. too fast. You want to ensure that whatever point it is that you're making it clearly. And if you're talking too fast, the judges might miss out what you're trying to say. So that's another thing that I noticed and I saw. Now, when you have been asked a question, I know you're trying to make your arguments for that question, but if the first answer requires, I don't understand. I don't know. I think it was it. I don't know. I think it was. Yes, so Sarah, I think you have been asked a question and then you were trying to explain. If the first answer, you can give a very clear answer at first and explain why you are giving that particular answer. Yes, so I think for me, that's what I have to say to the contestants. You did a very good job. You can get better at what you have done. And the issue of timing is also very important. I think you should be more conscious of time, in your next presentation. And I think with that, you'll be fine. I'll be okay. Thank you.
Thank you very much, George.
Thank
you very much.
So, George Oyaleto, please, over to you.
Thank you, my lord. Counsel, I observed vividly that you were debating. It's not a sort of debate contest. You are before a court. And you are before a court trying to convince their excellencies on certain issues. Did you raise your issues? Were there issues raised? What were your issues? If you want to address the court, you must first say, these are the issues you want the court to address. You did not bring out issues for us to look at. You just started, kicked off like a debate contest, and you started talking. No, it is not how much you have said. It is how well you have said it. You believe the more you cover. Of all the retinue of facts you have to bring out issues for the court to address. And you support your issues with authority. Relate your issues, your facts, bring out issues, and support with authority. Trying to convince the court to take decisions in your favor.
Dr. Afel.
Yes. I can hear you. Are you hearing me? Can you hear me?
Sir, you are not very audible. Sir, you are not very audible.
Okay. Can you hear me now?
It's still very low, sir. We are struggling to hear you.
Maybe that is that must be the network. Hello.
If you can put off your video, let's just hear you. Let's see if it will help. If your video is off and just the audio, sir.
Okay. Yes. The video is off. Can you hear me better?
Yes, it's better now.
Yes, what I'm trying to say is that they are before their excellencies, and the first port of call should be that they should put before us their issues. Please, I hope the coach for team 21 or what is off. I hope the coach is off this room. The coach of
team 11 here. Only have team 11 here.
I know team 21. I hope their coach is also gone.
Yes, gone.
Okay, not just the students. So what I'm saying is that they ought to have raised issues they want the court to address. So at the beginning, you did not state your issues. If you have one issue, two issues, three issues, no issues were formulated out for us to address. And you handled it as if you were carrying out a debate. It's not a debate, you are addressing the court. So in addressing the court, we must be directing our minds to the facts, issues, and law. So the issues were not there. Then also I observed that when you cite authorities or you are quoting a text, you did not seek the leave of the court. You don't just go directly. If you refer us to an authority and you want to quote it, you must seek the leave of the court. So that is it. You raise issues, then you canvass issues, then you seek the leave of the court before you read from any text. Thank you.
Thank you very much, Dr. Oyaleto. We are very grateful for your insightful comments. And then the team 11, you have done very well. I want to congratulate you guys. I mean, to prepare and appear for such a competition is not an easy task. I mean, those who are participating in it alone need to be congratulated, need to be commended for their industry and the effort they've put in. Now, in participating in such a competition like this, you have to have a grasp of international human rights law and then partly international law. And then you must understand some basic principles. I mean, what is the status of subsidiary jurisdiction? I mean, subsidiary courts and all that, the types of jurisdiction and all that. So you have to try to go and read up on all those things, and then so that you brush up on your knowledge. And then two, try not to be too fast. I understand the passion, I understand the zeal, but don't forget, if you are too fast for the judges, they may not really follow your argument. And then number three is that the questions are there for you to shine. Now, when they ask you a question, try to, for instance, I was asking Genia about, you were the one that raised, what's it called, paragraph 27. And then I was asking whether it was peaceful protest and all that, where I was trying to beat about the bush. Try to be factual about, you cannot read into the fact. You have to work within the fact. That's one of the rules. You cannot import into the fact. And then, so I think, once a question is asked, listen to the question and don't beat around the bush. Answer the question. Even though you have other additions, first answer the question before going to talk about the other issues. And then I think, I don't know, you said that the answering of question is your time is to be paused. I don't know, possibly that would have been an oversight, but that's not the rule. As the questioning is part of the whole competition, and your time is counting and all that. And that's why we are magnanimous enough to put that into cognizance. That's why I'll give you like 2 minutes to wrap up and all that. So it's part of it and all that. But by and large, it has been a very wonderful outing for you guys. And then I wish you guys the very best as you progress for the next session. So all the best. So at this stage,
thank you very much.
Everyone is allowed to exit the room as this brings to an end the session for today.
So before we exit the room, I would like to ask a question.
Yes, please.
Okay. So for the appearances, the parts where we introduce ourselves and announce and identify our issues as Dr. Fair instructed, we just want to know that all of this introduction, the timing, does he enter? Does he enter into the timing?
Your timing. Listen. Now, once you start to speak, you start to speak. There's no really to my name is this and all that. Listen, I'm the co-agent or counsel for the applicant. With me, your time starts counting. So you don't need to go to town. Your time starts counting. Once you start speaking, that's when your time starts counting.
Okay. Thank you. Really noted. Thank you very much, sir. All right, sir.
All right. Yeah, bye. Yeah. You can exit the room now. So, fellow judges, now we are alone with let the student leave. Then we'll now talk to ourselves as judges.
I think their coach should exit as well. Please, the coach
Everybody
should
should
exit.
leave. All the team, the coach, and all that.
Okay. They've exited, sir. You can go ahead.
Good. Dr. Afioyalito, Dr. Adebari, I want to first appreciate and express my deep gratitude for you guys finding time out of no time to attend. I mean, this is the first day and the first session. More often than not, we know everything. The first is always a bit a struggle, but we thank God that we have been able to pull through. Notwithstanding the fact that what's it called, Team 21 was not able to scale through. But nevertheless, it has been a good one, not a bad outing at all. So, bottom line is that in this type of, just to address the issue Dr. Yaleto raised, in this type of mood, you don't usually, they don't have the time to seek leave. It's like talking to, unlike the regular court, there's nothing on leave. We should not forget that it's both an academic exercise.
Dr. Olushola, we are training them to be counsel, to know how to do things in courtroom. It's not a question of whether they have time. It's not a debate. It is a court session. And they must
Hello, sir.
Courtroom.
Hello, sir.
Hello.
Sir, for just a minute. Team 11, I'm seeing Team 11 coach. Please, can you exit this meeting? Please? Thank you. Team 11 coach, please exit.
Remove.
But we
Go
said
ahead,
that
sir.
earlier. That is an unfair play.
Go ahead,
That
sir.
is an unfair play. And I can hear you. That is an unfair play by Team 11 coach. There was a directive, but she chose to stay behind. He or she chose to stay behind. There must be a penalty for that. So hear us.
just let proceed.
No, it is an unfair play. Please, I don't.
Yeah, not to have, because I said everybody should leave. I don't know why I was saying the rule.
Yes, and
but I
he
think
did not leave.
they are to have the power to exit.
It can cause them. Sorry, sir. It can cause them disqualification.
I think they admit to have the power to exit everybody. They should have the power to exit them.
Please, the admin should live up to this game, please. Don't let somebody outsmart us. Now, what I'm saying in essence is that it is courtroom practice that we are teaching them. It's not about time. They must know the nitty-gritty, what they will do when they are addressing the court. So it doesn't even mean they will wait. Sometimes if I do it in court, I don't even wait for the judge. Did you leave of this honorable court? I seek to read. I continue reading. Even before the judge.
Yes, I agree with reading.
Seeking the leave of court. Let them know that they must use that time. They may not necessarily pause for us to say go ahead.
I agree. Yes, I agree. Thank you very much. Dr. Adebari, anything you want to say?
No, nothing really. Thank you. And I just, the issue of Your Excellency and my Lord, I don't know, maybe you can give me more clarity on that.
Yes, international food competition or human rights commission generally, just address as Your Excellencies. Thank you. We really appreciate.
No, doctor, it's not about competition. It's not about competition. Judges of international court are addressed as Your Excellency because they are representative of.
That's I'm on the same page with you. It's from that culture that we try to use excellence.
We are sitting as an international court.
Yes,
not
that's
as
true.
a
That's
state
true.
court.
That's
That is why they are addressing us as Your Excellency.
That's true.
So we are
That's
seen
true.
as representing various nations.
That's true.
Right,
That's true. I agree. I agree. We don't know whether the admin has anything for us. Do you have
Yes,
anything to
sir.
say admin before?
Yes, sir. Sir, please, I would just, I don't know if it is just for 2 or 3 minutes. I would like we have some of the judges from the next session, because we weren't able to debrief the judges. That's why we're having some of these issues coming up. I don't know if you can just briefly address the judges that are here right now for the next session quickly so that when the next session will just go smoothly.
Okay, thank you. The fellow judges in the room, it's a very good one. I mean, that we are participating in this type of exercise. I mean, I was having a conversation with somebody yesterday about I came about seeing one of the lead judge for the finals and the semi-final because of she's been doing this type of thing and posting it on LinkedIn. And I've seen it a couple of times. She acts as a judge, both in local commission and international commission. That was what prompted our invitation. So what it means is that while it may look harmless and look a bit simple, I mean, we do not know what we are going to do that is going to pave way for something bigger or greater in our lives. I mean, because definitely this is just a service to humanity. No amount of whatever they want to give us will be able to reward our time, but we are just trying to shape the life and future of our lawyers to be. So be that as it may, this is a moot court competition. Is not a mock trial. A mock trial, students are expected to wear their regalia, do all the formal court setting and all that. But in a moot court competition, it's a pseudo court whereby academics is mixed with court setting. So what it means that is a dual carriage exercise, an academic exercise on one hand, and also a court exercise. So we try to gun the students' skills, so for them to own their skills, their advocacy skills, in terms of arguing and all that, and also for them to equally broaden their knowledge on various international human rights principles and international law principles. So what does that imply? It means that it's not a regular court session whereby most cases the judge just sit down and look all throughout the court session without interrogating, without questioning the what's it called, the counsel or the lawyer. So in this case, judges are expected to interject, especially when they are making arguments that you do not agree with, or arguments that are not in tandem with the facts. For instance, the last session, the counsel was saying that the protests have been peaceful. But I showed him there in paragraph 27 of the fact that no, it wasn't peaceful and all that. So he would have been able to rigmarole himself out of it. He was very intelligent enough and all that. But there's another paragraph, I think paragraph 14, that talks about the protest being peaceful. So we as judges must first have an understanding of the facts, because most times our questions must border on the facts, paragraph what of the fact, and then the relevant law. So if somebody is just talking, say, please, what paragraph of that fact? What paragraph of the fact? The candidate must be able to show you that is paragraph 5. And then it's also good for we as judges to have the fact in front of us. So that when some people may just say paragraph 5. Well, if paragraph is not with you, not be able to, if the fact is not with you, you're not be able to go say, no, paragraph 5 does not say that. Paragraph 5 does not say that. And paragraph 6 is what says. So we need to test their knowledge on the facts, knowledge of the facts, and the law. So we are not expecting talking about, and they did this, they did that. They must be able to point it. Paragraph 5 of the fact, paragraph 6 of the fact, paragraph 10 of the fact. And then the cases, according to SERAC and Nigeria, according to this and this and this. they must be able to demonstrate the knowledge of the law, not only law, relevant legal principles, pacta sub servanda, or monist principles, dualism principle, all those things. Because that's exactly how the student will learn. If they are not being asked questions on these general principles, they will not learn. And like God be so, the judges are encouraged to engage the student. But at the same time, we must equally be mindful of their time. I mean, it's not too good if all the three judges are asking three questions for a team from a team. what time is left? But I mean, two judges may ask from one, another may ask two questions from the other candidate. The other, when the other team comes, another judge may ask two and one and all that. There's no crime in that. But we appear to be unfair. If, for instance, all the questions are directed to only one team, and the other team, we are just looking at them like this thing. Where there are no questions, we will try to just stop them and say, please, that argument, can you say it again? I don't agree with you because so and so and so and so. So you just ask them for them to rephrase, and then, because if they are just talking without trying to pause them, they may just feel that maybe judges are not good there. Or number two, maybe judges don't have knowledge of the fact, do not have knowledge of the law. So I think we must equally let them know. Because, for instance, I asked that lady the question that you raised the case of Serach and Nigeria. On what basis is that, or what's the status of that decision before this court? It would have used Article 60 of the African Charter, which provides that court are to draw inspiration from what's it called, decision of other courts, other human rights bodies and all that. But obviously, she never knew the answer. So, and that's why. So I think so. Those are the nuances around the competition. It's supposed to be a very lively one, where the judges are engaging the students. Because I'm very sure the students will feel a bit unconnected with the judges. If judges all throughout the session, the judges are just looking like this without asking from the beginning to the end, no question, nothing. They won't wonder if the judges are still there, or if possibly they won't listen to them. So I think what's it called? The judges will try to engage the students from the beginning to the end, but it must not be lopsided. It must be equal as that, because of students, they are during our time. Because don't forget that the coaches are there, they are watching. That judge is so biased. He asked 100 questions from our team. When they get to the other team, no ask one question. So all this, definitely none of us is biased here. We don't know which team is which is which. We are just here as teachers, we are here as lawyers, we are here as academia, just to help the students. And we are being objective, being biased, and free from any encumbrances in terms of trying to help or trying to pull down any student. We are here for them to be fair as much as we can. I think when judges to sit, I think the presiding judge is supposed to pick one of the judges as the timekeeper, and then so that we don't interject in terms of when they are putting. That's why we have the chat box there. I mean, the so-called judge should be putting it there. If they are spent, maybe if they are using 15 minutes and they spend 10 minutes, it's also put it there, 5 more minutes, so that the presiding judge should be following the chat box. So it'll be 5 more minutes. And when you put it there, time is up. The presiding judge can use his discretion to add 2 minutes, 3 minutes, 4 minutes, 5 minutes. I don't know, for whatever reasons. If, for instance, at the point in time, the court could not hear the candidate, maybe, and he has lost about 3 or 5 more minutes, that can be computed to lead to additional 5 more minutes and all that. So it all depends. But in a case whereby no minutes were lost except for the questioning, 2 or 3 minutes is fine for them to wrap up their thoughts in such a competition. But and then another thing is that if you are giving 2 minutes to applicant, you have to accept the respondent is able to finish before time. If, of course, they are unable to finish before time, the same 2 minutes you have given to the other team, you have to equally do the same. So to ensure fairness of the process. I think these are some of the issues. But more than any other thing, I think all judges have to look at the fact. And then the beautiful thing about the fact is that there's a video simulation on the YouTube. You can watch it and be able to pick up the facts have been designed in a way that there are loopholes for both the applicant and the respondents. The applicants have some loopholes. The argument definitely have some loopholes that call for questioning. The respondent equally have some loopholes that call for questioning. It's an academic exercise so that the two teams are well drilled and well interrogated. And then once a question is asked and we discover that the student is trying to is grappling with it, is not really getting it. It is duty of the person that has to go and say, please, don't worry, proceed. Because you don't want to allow him or her to be wasting all the time. Say, when you just say, he's trying to, I can that this one does not understand the question. Say, okay, don't worry, please. You can proceed to the next issue. You don't allow the student to just wait there and be talking. For instance, you're asking A and Z is going to Z. Your God know that the person does not understand. But okay, please, I can't say no problem. Can you proceed to the next issue so that it does not waste the time of the court and equally does not waste the time of his or her thing. So I think that's it. So let all the judges try to engage. If you don't want sleeping judges, I know some of my students will say, this court that we attended, only one judge was alive, the other judge was sleeping. So we don't want sleeping judges. We want all the judges to be active. At least when they just one question, I'm very sure there's going to be an issue that you think you really want to ask them question about about 5 issues. It could be on jurisdiction, it could be on eligibility, it could be on the 3 main issues. You just try to say, okay, I'm going to ask them question on this. Maybe peaceful assembly, maybe right of children, maybe environmental rights, or maybe illegal detention, withdrawal of the ratification, and all those things. NGO status. Do all NGOs have right to bring matter before the court or not? There are 1,000,001 questions that can be asked on this memorial. Sorry, on this fact. So I think we must maximize that to make the competition enjoyable and interesting for both the judges and the students, so that at the end of the day, the people that want to have as semi-finalists and the finalists should be the best of the best. So that not that we get to semi-final, people ask, how did they even emerge at semi-final? How do they emerge at final? We want to see people when they come for semi-final say, these people that arrive here, yes, they are very, very good. If you have attended the International Moot Court Commission, you see people that get to the semi-final. It's not a tea party. They will be extremely very good. That you don't have to doubt the idea that, oh, truly this process that brought them there have been very fair. It will be clearly shown that these are very good teams. And at the final, you're going to get the best of the teams. But that will only happen if we judges engage the students and find out their real worth and their real capabilities. If we just sit behind the screen and we do not ask them questions, we do not test their intelligence, God forbid that the wrong teams get to the semi-final or the final. And then I think the last thing I want to say is about the scoring sheet. Now, the scoring sheet has what's it called? Applicant and respondents for each of them. Each score sheet has 2 sections. So I think the judges are supposed to write. For me, I've done it. You're supposed to write like this one, the first one, you are going to put applicant on it. This is the score sheet for applicant. And then for the respondents, I've written respondents on it. So that when the admin are trying to collate, they do not give A to B and B for C. So each session, 2 score sheets, 1 score sheet for the applicant, where you put, for instance, this is Sarah Tere. These are score. These are co-agent Abdullahi Ajenia. This loan script. So you do that. You write what you feel about their presentation, and then you do the total and you sign. After you sign, you scan off. For instance, if it's e-copy, you just attach and send to the admin so that they can start collating the results, so that by the end of the whole competition, and don't forget, all these scores should be sent to the students, so they are going to see, so that sometimes they have to calculate their marks themselves. If they find that there have been some mistakes, they'll get back to the organizers. So the organizers have their work cut out for them to ensure that the points are correct, the marks are correct. So please, judges have to get this done. At the end of this session, you fill it and send it to the admin through the emails that we provided. So I think beside that, I think everything is fine, except there are questions about everything I've said or anything I've said. So I'm open to respond to these questions for the judges that are in the room at the moment. Thank you.
Okay, so briefly, then, do we have any question before we call this session to a close?
Yes. Sorry. This is Omoshola. I want to ask a question. It's not as regards what he has said, but as regards what happened this morning when Team 21 was asked to exit and they'll be rescheduled.
Team 11, okay, is it Team 11 or Team 21?
I think Team 21 was asked to, because of the fact that they were not
ready
for
you are correct.
session.
It's Team 21, Team 21, yes.
So what I'm saying is, if you reschedule another session, don't Team 11 have the right of reply to them? Don't you think Team 11 is meant to be there when they are giving their own presentation?
We'll sort that out, man. We'll sort that out. That will be sorted.
That will be resolved by the LOC.
Okay, I just wanted to know so that
that's a decision that will be made by the
LOC to the other.
Yeah.
Okay. Thank you.
Okay, so thank you very much.
Any other question?
Is there any other question, please? Any other question? The only thing
I can see dear Kolola, hope you are good.
Is he here? Okay, yeah. He was here. I don't think he's here.
He
has left. Yes. Okay. But Mr. Samuel will be joining us for the next session, and he's also here.
Okay, Mr. Samuel, I believe everything is clear.
Yes, everything is clear. Thank you.
Thank you very much, sir. Yeah.
Okay.
All right. So we'll see when it's 1 p.m. I'll share the link with those of us that joined the session as well, just so that we'll observe and see how it goes. Thank you very much.
Thank you very much, ma'am. Thank you. Bye, everyone.
Thank you. Have a great time. See you later.
And you too. Yeah. Bye.